Thanks for inviting me, and thank you for that very lovely introduction, Yvette. Hopefully I won't disappoint today. I do want to say a couple caveats before I start. This is a very early paper, so it's definitely a work in progress. It's not at the highest standard that one might hope for, but that was deliberate. I had another paper that is much more polished and ready, but I thought this crowd actually would be a good crowd to get feedback on this and in the early stages of thinking through this work. And so, although I'm not going to talk specifically about the Northern Ireland context, I'm not speaking anything to what's going on right now, I'm hoping that there will, if there's kind of parallels and resonances, that they can come out in the discussion, as Shad had mentioned. The other thing is, methodologically, the way I'm presenting this today is very much in the series of kind of stories and images, as opposed to, I'm not pulling out a lot of the kind of more empirical evidence that will come later as I'm kind of gathering things, but I'm trying to sketch out kind of some different ways of thinking about the relationship between resistance and punishment, and how certain things get considered to be legitimate political resistance or dissent and other things don't, and how those contribute into different ways of normalizing punishment. And I'll say more about that. So I'm trying to think a little bit about the social and legal responses to dissent, expressions of dissent, and I'm drawing from two examples. So the London August 2011 riots, as they've been called, or the English riots of 2011, and the Occupy London Stock Exchange movement that took place in St. Paul. So I'm very much focused on London, and I know people outside of London are often quite critical of the London-centric focus, so I'll apologize that for the beginning. Part of my interest in that is I live in London, I live in Hackney, and so I was very much present while things were happening, and also I have connections to the Occupy movement, and although at the time I wasn't deeply involved, I was passing through there and spending a bit of time there. So I was first struck by the very different responses that both of those events had. The public response, the legal response, the policing response, and how dramatically different they were, the response to those two events, even though I saw those two events as very much expressing a similar form of political dissent against the prevailing economic, policing, political order. And so that's what I'm partly going to trace out, but I'm also trying to look at the way in which the punitive response in particular to the riots was one that I think reflects broader trends of punishment becoming much more pervasive in other elements of society rather than just the criminal system. So punishment is moving into social policy, into educational policy, into many other elements, and it's spreading, and I want to kind of look at that. And in some ways, the context for this, of course, for me, is that we live in the era of mass incarceration. And so the questions among legal scholars, among sociologists, around social responses to dissent is clearly a long-standing one. There's nothing new about that. But in terms of the historical picture, what is relatively new is this kind of mass incarceration that we are experiencing in liberal Western democracies. And so I'm sure everyone in the room will be familiar, but never before in history have we locked up the number of people that we do currently. So, the US takes the lead with 1 in every 100 adults behind bars, and they're kind of held up as the, terrible, terrible example, but countries like England and Wales are certainly following suit and basically doubled their prison population in roughly 20 years. And I was shocked when I first came to England and was surprised by the level or the lack of resistance to that you could have your prison population essentially double and people just sort of let that happen. And there didn't seem to be a big movement against that, which is quite different from some other places. And that I'm interested in, sorry, this is a bit of a digression, but I just want to give you a sense of the context of where I'm coming from in my work. I'm interested in that fundamental contradiction between liberal democracies holding up freedom as being kind of the pinnacle value, the most important value, and yet we see in a trend across many Western liberal democracies where incarceration rates are continuing to get bigger and bigger and bigger. So how can you have these two things together? And part of what my work looks at in the project that Yvette was referencing, this queer investments in punishment, is I'm interested in the way in which social movements in particular have gotten funneled into what I would call punitive politics. So lesbian and gay rights movements that are invested in things like hate crime law, which is about locking up other people to protect LGBT people, or the feminist anti-violence movement has very much become kind of embedded in a certain law and order agenda, and how that's happened, so that incarceration and punitive responses, which used to be seen as a kind of sign of certain kind of right-wing politics, is now reframed as a certain kind of progressive politics. I.e., if you lock up someone that threatens to hurt me, that is a sign of your love and care for diversity, right? It's that kind of thing. And so I'm interested in here when we look at the response to what happened with Occupy, which I would argue was the legal response was very much a civilizing process. It literally was a civil dispute over property, but it was also a process of bringing people into the legal fold, whereas the response to the riots was part of excluding people, pushing people out, in some ways being ungovernable subjects that have to be pushed out and abandoned and subject to what we might call social death through punitive politics and imprisonment. So I'm not going to talk specifically about the Queer Punishment Project, but if people are interested in that, we can talk about it in the discussion. Okay, so now just to start, in using these two sites or these two moments as a point of comparison, obviously there's some key differences and people might suggest you shouldn't be comparing these two things. And so I'm not trying to suggest that they're not different or that they're the same. Clearly there were differences in terms of who was involved, the location. I think sometimes there's been a blanket assumption about the riots that they were all the same, and the actions in particular boroughs were very different. Like the feel of them in terms of whether they were more anti-police, whether they were directly confronting the police or running away from the police, the amount of looting that was going. A lot of the kind of reports and evidence has suggested that they were quite different. So I'm aware that there's a risk of kind of collapsing those things, and I don't want to do that. But I want to think a bit about the responses in terms of how certain narratives play out, how certain stories get told, and how they shape the broader landscape of punishment and punitiveness. And I want to argue that both events can be understood as expressions of political dissent against the prevailing economic and social order. I would say both represent a sense of wider discontent with political elites. And both can be understood as disputes over entitlement to space, property, and economic security. And I know for some people this may be a more controversial element of the argument, but you could say at an ideological level that's probably clear that both the riots and Occupy were a dispute about the disparity of wealth, for example. But even on an instrumental level, both can be read as property disputes. So in the case of Occupy, it was a dispute over the use of public space. Like when the legal case actually panned out, it was, can we stay here at St. Paul's? In the case of the riots, we could argue it was also a dispute over property in terms of ownership, entitlement, and access of commercial goods, of street space. So we could think of this in terms of occupation of property versus property possession and damage, but there's still, we can argue, disputes about property. Yet the way the response was that one, as I said before, was translated very much into a civil dispute, and another was turned into very much a criminalization and punishment process. Okay, so that's the kind of broader picture. Now, the kind of theoretical framework that I want to use here is drawing on an older essay by Nicholas Rose from 2000. No, it's okay. Sorry. There'll be lots of pictures in a bit, but I had to do that first. Yeah. No, they're coming. Don't worry. Okay, so I'm drawing on some work by Nicholas Rose where he talks about circuits of security and circuits of insecurity. And I'm sure there'll be people in the room who are familiar with this essay. And he talks about circuits of security which operate through strategies of inclusion and circuits of insecurity which operate through strategies of exclusion. And part of my argument here is that I would say that even though Occupy activists were dissenting against the system, they were ushered into the system of security, of inclusion, if you will, into the system, into respectable, self-governing, disciplined subjects, whereas the rioters were very much pushed into circuits of insecurity, precarity, abandonment, and social death. Now, Rose suggests that while contemporary control strategies are incredibly varied and situationally contingent, new modes of security have a kind of strategic coherence that allow us to see patterns in regulation and discipline. From this perspective, control is exercised through circuits of security, which operate through inclusion, and circuits of insecurity, which operate through exclusion. The former draws upon inclusive identities, so he talks about technological and consumer-based identity practices, which function simultaneously as access points for citizenship privileges and as conduits for regulatory surveillance. You can think about things like membership cards. This is classic governmentality thing where you have your customer loyalty points, so you're ushered into a realm of citizenship and through belonging and through purchasing, but you regulate your behavior through the tracking of information about you. Also in terms of partners in prudence, so states which function as facilitators and managers rather than care providers, and territories of security, so contractual communities which offer discrete spatio-ethical zones. That's the language that he uses. Now, circuits of insecurity function through subjectification, i.e. distinctions between successful, responsible citizens and failed non- or anti-citizens. Circuits of insecurity operate through risk management, so regulating rather than transforming levels of deviance, and through responsibilization, so efforts to propel excluded individuals from dependency to activity. This is the shift that welfare changes, and penal welfare strategies, so practices which seek to contain individuals who are viewed as impervious to the demands of the new morality. So you've got people who are in the kind of responsible citizenship, self-regulating, governing subjects. You've got the people who are sort of in between and need to be ushered into that space, and then there are those who, they're a lost cause, and we lock them up and throw away the key, if you will. Through these circuits of regulation, Rose considers how contemporary control strategies operate less as an external, coherent force that imposes itself upon a unified subject, and more as a dispersed, infused, and immanent power, one that is not repressive but productive. So conduct is, quote, conduct is continually monitored and reshaped by logics immanent within all networks of practice. So for any of the Foucauldians in the room, this will all be familiar in terms of he's very much using a Foucauldian governmentality lens here. And for those of you who are not so much into this theories part, don't worry, we'll move along shortly. From this vantage point, the state is neither the only force engaged in the government of conduct, nor the hidden hand orchestrating the strategies and techniques of doctors, lawyers, churches, etc. Rather, the government of conduct, far from seeking to crush and eliminate the capacities of action of those persons and the forces they act upon, on the contrary, seeks to foster and shape such capacities so that they are enacted in ways that are both broadly consistent with particular objectives, such as order, civility, health, or enterprise. These changes can be seen in a number of overall trends: a recasting of the state, a fragmentation of the social, and a reconceptualization of the individual as an autonomous, prudent, and responsible subject. It's important to note that neither of these circuits are spaces of freedom. So circuits of security are not necessarily ones of freedom, and circuits of insecurity are regulation. They each invite subjects into different kinds of discipline. One that is self-managed and governed, on the other hand, in terms of subjects that are governable, and those who cannot govern themselves and must be relegated to the prison, the ghetto, or spaces of social and economic abandonment and neglect. Okay, now there's a number of other theoretical frameworks that we could use, and in my other work I actually use Mbembe's essay on necropolitics, which is offering a corrective to kind of Foucault's work on biopolitics. If you're interested in that, I can talk about it in the discussion. I think that emphasizes more the kind of politics of death that are very much at work in the prison, but I'm not going to use that today. Elizabeth Pavanelli's work on economies of abandonment, or even Butler's work on precarious life. Those are other similar frames that I think are trying to do the same kind of work. But I'm using Rose here because I think this notion of circuits of security I think is useful with these two examples, because I think very much there's a kind of funneling of people into certain realms and other realms that is quite spatial. And so I think that is a useful framework. Okay, so let's go to the riots. Two photographic images linger from the civil unrest that swept across England in August 2011. The first depicts a lone male figure in the street, stepping brazenly in front of a burning car. Clothed in a gray tracksuit and black sneakers, with hood up and stance defiant, he embodies the demonized figure of the hoodie that has come to symbolize dangerous and troubled youth in Britain. The black scarf that covers his face adds to his ominous persona. Though his skin is not clearly visible, he evokes the aura of stigmatized blackness. His gaze is cast slightly upward from under the shadow of his hood, as though he has just caught a glimpse of those who are watching. He does not care. Starkly framed against the thick black smoke and bright orange flames that engulf the wreckage behind him, he inhabits this danger zone as though he owns it. Now the second image, just jump back, sorry. The second image directly contrasts the first. This photo depicts a fresh-faced white woman in her 20s, sporting trendy sunglasses and a crisp yellow tank top. It is sunny and bright outside, and a friendly crowd stands behind her. With broom in hand, she is part of the voluntary post-riot cleanup crew, the Broom Brigade as it was fondly described in the media. Her body bears the markings of class privilege, neatly groomed and poised, skin free of tattoos, piercings, and loud jewelry, clothes simple and modest. She embodies both the conventional domesticity of gendered labor and the public self-discipline of civic duty. Her long blonde hair is swept back in a ponytail, and she is ready to get to work. Yet her task is not simply a menial one, it is also pedagogic. Emblazoned across her chest in a carefully ordered, hand-painted letters is a clear moral message. Looters are scum. Behind her is a sea of white faces, respectable middle-class do-gooders who have come to clean up the streets, to sweep away the dirt and debris, to cleanse the events that shook fear into Middle England. Now, I'm starting with these two contrasting images because I think they both evoke particular truth narratives that have come to explain the events of August 2011. Both of these images were widely disseminated in the media. They might be familiar to you, and recirculated on popular blogs, websites in the weeks following the riots. And their representational power, I would argue, lingers because they tell familiar stories about criminality and danger, about law and order, about individual accountability and big society responsibility. And I would argue that these photographic narratives work not only to naturalize the punitive state responses that followed the civil unrest of August 2011, including lengthy prison sentences, violent police raids, increased surveillance, and social benefit sanctions, but also work to re-entrench the circuits of security and insecurity that Rhodes describes. So the events of August 2011, I'm sure most of you are familiar with this, began with a peaceful demonstration outside a police station in Tottenham to protest the fatal police shooting of 29-year-old Mark Duggan, and subsequently erupted into 5 days of rioting, looting, and burning in cities across England. Clearly, these were signs of widespread rage, disaffection, and malcontent, and stemmed from deeper problems that had been brewing for years. While the mainstream media was keen to present rioters as feral youth gone amok and anarchy in the streets, these were acts clearly of expression of anger against the violence of poverty and deprivation in general, but also against the violence of policing in communities that have experienced years of targeting, stop and search, and deaths in custody. And I've just included this image here because I think one of the things in one of the classes that I teach, we do a whole unit on, or a whole section on the riots, and one of the things that some of the students who are not from communities that are over-criminalized, they fail to understand the kind of legacy of deaths in custody, that in certain communities this is a major problem that has a long history. And I often show this image because I don't know if people are familiar that every year there's an annual Friends and Family demo in London where family members who have lost someone who's died in police or prison custody, they gather together to remember those, and they march to Downing Street in protest. And those are the list of names from the banner. And you can see, you kind of get an indication. There are lots of demonstrations in London, as I'm sure you know, at Trafalgar Square, but the racial composition of this demo is much more, it's a much more black demo than many of the other demos that you see. And so there's also a kind of indication of which communities are experiencing this, the legacy of kind of death and policing in their communities. The other thing that we just might point to is some of the material that came out of the Reading the Riots report. Now, I know there have been lots of critiques of the methodologies and various aspects of these reports, but I do think there's something quite significant about it was the first report to come out that actually interviewed people who were participants and involved in the riots, and I think that doesn't often happen as much as it should. And though the information that came out, so it's hard for people to see, but in terms of reasons that people were giving for why they were involved, at the top of the list were poverty, policing, government policy, unemployment, shooting of Mark Duggan. So these were clearly, according to this research anyway, this was not simply kind of anarchy in the streets. This was something else that had been brewing. Yet I would argue that this issue was consistently underplayed in the media. So to give an example, after the initial set of riots in Tottenham, the neighborhood was actually filled with lots of anti-police graffiti. This was the same in Hackney. Anti-police graffiti all over the place. You could not see those images in the media. The media was much more concerned with the kind of rioting or the looting images, the kind of police confrontations, the kind of political, the deliberate political message that had been literally spray painted on the walls in many places was very much erased from the story. Another thing to bear in mind is that there was a big clash between police and local residents on the Pembry estate. It got known as the Battle of Pembry Estate. But what the media also didn't mention was that 3 days before the riots, the police had undertook dawn raids at the Pembry estate. They had targeted 32 addresses and made 23 arrests on one housing estate. And so clearly the kind of anger coming out of that continued police targeting, I think it would be hard to say there wasn't a relationship there between the direct policing confrontation that happened, and that confrontation was not about looting again. It was a kind of direct, clash with police. Okay, and just so that's a bit more of the context. So rather than seize the moment to confront these kinds of issues, the underlying issues that were at stake here, the government chose simply to extend its law, order, and moral responsibilization agenda. So on August 9th, returning early from his family vacation in Tuscany, the Prime Minister issued a public warning. Quote, "I have this very clear message for those people who are responsible for this wrongdoing and criminality. You will feel the full force of the law, and if you are old enough to commit these crimes, you are old enough to face the punishment." Reiterating these comments the following day, Cameron then announced, "Anyone charged with violent disorder and other serious offences should expect to be remanded in custody, and anyone convicted should expect to go to jail." This was no mere political rhetoric. Cameron's edict translated directly into practice, with more than 3,100 individuals charged for riot-related offences in the 12 months that followed. The main charges were burglary, 50%, violent disorder, 22%, and theft, 15%. Of those who were convicted, 66% were given immediate custody, with an average custodial length of 17.1 months. This pattern of sentencing was more than quadruple what would normally be expected. Sentences for similar offense during the preceding year had averaged at 3.7 months rather than 17.1. This surge of arrests had ripple effects across the criminal justice system, with courts working round the clock to process defendants. Police officers worked extended hours to make arrests, and magistrates' cases were routinely referred up to the Crown Court to enable stiffer penalties. The already overcrowded prison estate in England and Wales was stretched to its max, reaching its highest ever population peak at 88,179 prisoners in December 2011. Attempting to recover from its dramatic loss of control in the streets, the state responded with a spectacular show of criminal justice might. The police undertook a series of aggressive dawn raids, violently breaking down doors of suspected looters' homes to search for stolen property and arrest young people. These raids, which primarily targeted low-income housing estates, recovered relatively low-value looted goods such as shirts, trainers, and belts. And I realized I meant to put a picture of there's some pictures in the media of the kind of bounty that they had found, and should have put one up. It was interesting. These like small bags of clothing. Police and corporate media launched widespread snitching campaigns to encourage the public to identify and report suspected looters and rioters. Suspects' photos were splashed across the front pages of local newspapers. Manchester police launched a Shop a Looter billboard campaign, which you can see here. And the Met Police posted suspects' profiles on their Flickr photo stream with copycat websites created by members of the public. These tactics were designed not only to track down and arrest suspects, but to publicly name and shame them. In the week following the riots, the Crown Prosecution Service advised magistrates' courts to abandon identity protections for young people, who are usually granted anonymity, and instead publish the names and addresses of convicted youths where it was, quote, in the public interest to do so. Some speculated that this unusual decision was a direct response to Cameron's remark that the government would not, quote, let phony concerns about human rights get in the way of the publication of suspects' pictures. And here you get a sense of the kind of racial profiling that was happening in lots of the news media in terms of what faces were appearing in these kinds of images. Questions were raised about the proportionality of sentencing as well as political interference with the judiciary's supposed independence, particularly when it was revealed that magistrates had been advised to disregard normal sentencing guidelines for riot-related offences. There were many striking cases. A 23-year-old with no prior conviction sentenced to 6 months imprisonment for stealing £3.50 worth of bottled water. A 22-year-old sentenced to 16 months for stealing ice cream. I have a 48-year-old sentenced to 16 months for stealing donuts. Sorry, this always makes me smile. A woman who slept through the riots but was imprisoned for accepting a pair of shorts that had been looted by her lodger. She was subsequently released, but she had spent some time, and there had been implications for her. She was a single mom. And her kids, dealing in terms of her kids. And then the well-known case of the 2 young men who were sentenced to 4 years each for attempting to incite a riot via Facebook, even though their posts did not result in any such action. Despite appeals, most of the sentences were upheld on the grounds that the context of the riots constituted an aggravating factor that warranted additional punishment. Now, arguably, there could have been an argument made to the contrary, that it should be a mitigating factor, but that's not how it worked in the sentencing. And if you're interested in this, the case that was cited is Blackshaw and others, 2011. The consequentialist rationality standard that was so stringently applied to those who participated in the riots did not apply to those doling out punishment. Stiff sentences were publicly justified on the need for deterrence, despite the lack of evidence that longer sentences have any deterrent effect, a fact that even the director of public prosecutions admitted. Other punitive measures also followed, and this is the part where I'm interested in this expanding circuits of insecurity and security, this part here, where the punishment is kind of leaking out into other realms of social policy. So barely a week after the riots ended, several local councils issued eviction notices to tenants who had been charged with riot-related offences, including a single mother whose son had been charged but not yet convicted. The evictions applied to entire households, even if only a single member had been involved in the offence. Now, while the courts subsequently rejected these evictions, the Prime Minister made it clear that he would back councils' efforts to rid their properties of convicted looters. For too long, he said, quote, "We have taken a too soft an attitude on people who loot and pillage in their own community. If you do that, you should lose your right to housing at a subsidized rate." True to Cameron's word, in May 2012, the government released plans to enact a new mandatory power of possession, which would enable landlords to evict tenants for antisocial behavior and criminal convictions. This new power would limit discretion and force courts to issue evictions which met certain conditions. The proposed triggers for eviction would apply not only to the behavior of a formal tenant, but also to visitors to that tenant's residency. Most significantly, the proposed legislation would effectively allow councils to abandon their duty to provide accommodation in such cases. And so I'm going to read you a section. This is a bit government speak, but I think it's actually quite important. This is from the proposed, or the report. Quote, "Where tenants have been evicted for antisocial behavior, it is very likely that they will be deemed to have made themselves intentionally homeless, and therefore the local authority will not owe them a duty to provide new settled accommodation." So basically, if you were convicted of a riot-related offense or some other antisocial type behavior, that could be grounds to kick you out of your housing, and then the council would have no obligation to provide you any other form of housing. And of course, this goes back to the kind of rational, self-governing subjects that if you should have thought about your housing before you, decided to break the law or, engage in antisocial behavior or invite guests to your home that might engage in antisocial behavior. This notion of intentional homelessness adds a frightening weapon to the state's arsenal of anti-poor laws. The message is clear. Those who break the law and get caught are deemed to engage in antisocial behavior not only forfeit their basic entitlements, but will also face legally sanctioned social abandonment. And this is what I'm interested in here. This idea that it's actually, if the courts lose their discretion, and in certain cases they have to evict people, this is why I would use the phrase legally sanctioned social abandonment. As the head of Manchester Council aptly summed up, quote, "We have the power to evict people involved in antisocial behavior, and we are ready, willing, and able to use that power. Anyone involved in these disturbances or anyone who has allowed their children to be involved needs to understand that we don't want you in our community." Like parental responsibility orders, which hold parents accountable for their children's behavior, this new power of possession essentially renders whole households responsible for the actions of any one of its members or guests. No doubt this will have a particularly gendered effect, with lone parents who are disproportionately female bearing the costs, as has already been the case with housing evictions related to antisocial behavior. Such measures also reflect an inability to understand poverty as anything other than choice. As one commentator pointed out, the idea seems to be that those in social housing could just find somewhere else. They could walk into private housing. Like similar proposals for taking away the housing benefit from miscreants, it is based on an inability to imagine what poverty is like, to think for a second what might happen to a family when it loses its income or its home. Okay, I'm just mindful of the time, so I had some more, but I just want to get to the Occupy. I mean, part of what I would argue, just to kind of sum up this next section, is that the ability to, I mean, there was a petition, a mass petition, that, and it was the petition actually, you might remember that the government had said they would set up this new system where if a petition reached 100,000 signatures, that would trigger a debate in the House of Commons. The first petition to reach that goal was the one calling for people to lose their social benefits if they were involved in the riots, and that was all benefits. So I think it's interesting here, and this is what I'm talking about, the reference to the earlier stuff about Rose, that it's not just a kind of central state that's doing this work. It is very much these networks of punitiveness that are kind of pervasive at many different levels. And I would argue that the ability to do that was premised on pitching the actions of those involved in the riots or the unrest as non-political. That as long as they're not political, that we can say it is nothing but criminality. And so here's a quote from an MP that was published in the Evening Standard. Let's be clear, what we've witnessed across our London boroughs is not a genuine outlet of political angst nor a reaction to police conduct. It is simply criminality on a devastating scale. There is no excuse. The people looting sportswear stores, electrical shops, and department stores weren't thinking about what happened to Mark Duggan. They weren't thinking about the stagnating economy or public service cuts. Their motivation was to wreak havoc and perhaps grab a pair of trainers or a TV along the way. And so I would argue actually that even more liberal commentators that would argue that the context for the riots was political, most would still argue that the actions of the rioters themselves were not political. So it was a political context, but we shouldn't read those actions as political because they didn't have a clear political demand, or they weren't targeting the right people. There was always this kind of emphasis on, why are they targeting JD Sports as opposed to why don't they go trash the government buildings? And there was this deliberate, I would argue, depoliticizing of those actions. Now, interestingly enough, some of those critiques have also been made of the Occupy, that Occupy didn't have clear enough demands, that there wasn't a kind of single enough issue in terms of what the clear demand was for the alternatives. There was a clear critique, but not a clear enough demand. But there has never been a question that Occupy has been a decisively political action and political move. So I'm going to quickly talk about Occupy. I'll just sum it up as opposed to reading through, and then because I want to make sure there's lots of time for questions and discussion. So just moving on to the Occupy movement, it was clear that this was an expression of dissent against the kind of current economic order with its 99% slogan, referring to the 99% of the people who don't own the wealth against the 1%. And it's in many ways, it was an expression of dissent that had a very localized but also a global connection, in the sense that these, obviously people would be familiar that these were happening all over the place. The London manifestation in St. Paul's started in October 2011, so 2 months following the riots. It was inspired by Occupy Wall Street that had begun the month before in New York City's financial district. And the London Occupy action was literally originally intended to occupy the stock exchange, London Stock Exchange, but of course the police prevented that from happening, and so they set up camp next to St. Paul's Cathedral, where they remained there for the next 3 months. Now, I would argue the Occupy movement, although it's described itself as the 99%, for the most part it was organized by a particular slice of that 99. And this is not meant to be, to downplay the importance of that movement, and there's been a lot of heated debate about this, but I would say this was not necessarily, that movement, particularly at St. Paul's, was not representative of many of the people who are most in those kind of circuits of insecurity. So if you think, for example, a single mom who lives in Brixton, who's trying to work multiple minimum wage jobs to feed her kids and pay her rent, she doesn't have time to come to Occupy. You know, there were literally homeless people staying at Occupy, but there was also a lot of students, a lot of, middle-class people who have time on their hands. And so I would definitely not say that the 99% was present. And I would argue that this is part of the reason why they had the response that they did. I think if Occupy had been, primarily populated by young black men wearing hoodies, it would not have gotten the same response that it did. And so just to remind people, when Occupy first took St. Paul's, the police did act quite aggressively. And the police were violently trying to move people off. There was quite a lot of skirmishes. And if you recall, one of the figures in the church came out and asked the police, they said, "Thank you very much, we don't need you to do this, please leave the protesters alone." And then there stemmed from that the kind of debate about what to do, and there was a back and forth between the protesters and between the church, and eventually it went to the court proceedings to deal with whether or not an eviction order could be launched to remove the protesters from the site. Now, this is the part that I want to emphasize on, is how it got to be turned into a civil dispute stemming from the Highway and Traffic Act. At any rate, what happened was there was a kind of long, drawn-out court process. And so the first image that I showed you was actually on the steps of the court when they were waiting for the first announcement. Okay, so the question was whether the Corporation of the City of London could forcibly evict the camp. And what occurred was a rather drawn-out and very civilly contested order. At the end of the day, what happened was they lost and they had to move. And they removed themselves. There was no kind of confrontation. People voluntarily moved away. And so following the ruling, a number of groups issued public statements saying, quote, they would withdraw gracefully in a thoroughly British manner. Okay, now it's a minor quote in a press statement, but I think this is quite significant because I think this is part of the ushering people into the realm of kind of civility, respectability, and properness. I would argue this is partly because of being ushered into this court process where they were recognized as subjects who were worthy of making political dissent in the form that they had, which I would argue was actually not that disruptive. You know, it was very contained. It didn't disrupt business as usual like the riots did. And so I'm going to give you a quote. Sorry, that was the image that I was talking about in terms of the, even this image in front of the courts and, presenting people as having this dispute, adversarial dispute properly in the courts. But this is the quote that I actually want to focus on. So, So the day before the appeal decision came down, which granted the city authority to evict the protesters, there was a big group meeting where people were talking about strategies. And some of you will probably know Colin Gertie. He does lots of human rights work. And he wrote this blog. And he said, the discussion at Occupy LSX last night was about the role of law in seeking to change the way we understand the society in which we find ourselves. Interestingly, there was far less cynicism about law than there would have been 20 years ago. The excellent David Allen Green produced an anthem to law adherence, which was applauded rather than booed down, as it might have been not so long ago. David was right to remind us that lawlessness is something that the rich and powerful are more adept at and able to do with greater impunity, so that we need to be very careful before we write off the rule of law. It remains, as David said, quoting the great radical historian E.P. Thompson, an unqualified public good. Why did the rule of law get such an easy ride? I'd say this is because of the transformation we have seen in the English judiciary in the past 2 decades, moving from the blind defenders of the status quo that I recall when I first started teaching civil liberties in the Thatcher era, to the more nuanced, thoughtful people you encounter on the bench at the present time. An example of this was the Occupy LSX appeal in the Court of Appeal. The decision was due the next day. It went very well from the occupiers' point of view. They were treated with respect. Their lawyer was warmly congratulated for having taken on the case. The human rights issues were given the time to be developed. The individual litigants themselves had their chance to have a day in court that felt meaningful to them and was not just a charade. This is all excellent news. It does not mean that the appeal will succeed. I would still say the odds are stacked against. Now, I'll just say 1 or 2 more things and then we'll open it up. In this context, it's also worth bearing in mind the amount of public support that came in for Occupy St. Paul's. So within the first week, there were discussions about what to do with the amount of money that had been donated. something between 12 and 15 grand had been donated in that first week. And there was a dilemma because people didn't want to keep holding that money in a sock, but they also didn't want to put it in a bank because that would contest their values. But they couldn't open up a cooperative account because they didn't have any kind of corporation to do that. So there was a whole debate about money. But the fact that they got that money so quickly and the amount of public support, the number of lawyers who were ready and willing to defend this case contrasts quite dramatically with the lack of lawyers who were coming to support those who were involved in the riots. They were really struggling to find people to do pro bono work. Lawyers would not come out and say publicly, would publicly defend many of the rioters. When you think about the media coverage, everyone had to do that. I am not defending what they did before they talked about the kind of context. People who did try and defend what rioters had done had their blogs pulled from the Independent and from other places. So there was such a different contrast to the way in which the public and the kind of legal establishment really moved in to support Occupy, and I would argue abandoned those who were the defendants in the riots case. And so this is part of also what I'm looking at in terms of these circuits of inclusion and exclusion and security and insecurity. Okay, I had a few other things to say, but I've been talking long enough and you've been really patient, so maybe we'll just leave it there and we can open it up for discussion.